not feeling well.
Well, thank you. I'm better today. Yesterday was
Good morning, I'm Stephanie Simmons, and today could be the turning point in the trial of Tony Earls. Closing arguments are set to start at 11 o'clock this morning. Earls is charged in the shooting death of Arlene Alvarez, 9 years old. It happened on Valentine's Day back in 2022. Here's a live look right now inside the courtroom. Both sides wrapped up their case yesterday, and today the attorneys will make their final appeal to the jury. We have two crews there, Ugochi Loca and Anieli Ruiz. They will both have live reports coming up in our later newscasts. For now, let's go to KHOU 11 legal analyst Carmen Rowe with more on this. Carmen, thanks for joining us as always. So let's start with this. What is the goal for each side today?
Well, the goal in closing arguments is going to be to persuade this jury from the prosecutor's perspective that Tony Earls was reckless in causing the death of Arlene Alvarez. And from the defense's perspective, we're going to have a myriad of defense charges that are going to be given to the jury. Right now, they're in the middle of a jury charge conference deciding what issues will be presented. We can expect to see self-defense, perhaps a lesser included offense, mistake of fact, and protection of property. And they're going to argue that the state hasn't proven their case beyond a reasonable doubt, but that more importantly, some of these defensive issues may excuse Tony Earls' behavior on that critical night.
You've been saying this from the start, both sides of this, very strong attorneys. So from a legal perspective, what parts of the prosecution's case do you think were the strongest?
Yes, we have tremendous attorneys on both sides, which is why this trial has been so fascinating to watch. But make no mistake, John Jordan, lead prosecutor for the state of Texas, has made clear that the video evidence, the surveillance surrounding this shooting is the central evidence that this jury can and should rely on in determining the outcome of Tony Earls' future in this case. And so we've seen a lot of video evidence. I'm sure that the jury will ask to see that back in deliberations, but there's no question that has been the most important evidence in this 4-day trial.
When the trial started, we saw new video evidence from different angles, one close up, one where you could see more of the parking lot, which was a portion of where this happened. How influential do you think introducing those new pieces of video will be for the jury?
So the thing about videos that's very interesting when you watch a trial like this and you say it's all on video, well, then you start looking into all the nuances and the details of the video. When they added the sound into the videos and put a compilation type video in front of this jury, and then you had the defense challenging whether or not that was something this jury could rely on, and more importantly, from the defense perspective, whether or not that's what Tony Earls and his wife were able to view from their perspective on the night of this shooting. And so on the one hand, video evidence is great, but on the other hand, it can be interpreted differently by different people. So while it's compelling evidence, it'll be for this jury to decide exactly how to interpret that evidence based on their own personal experiences here in Houston.
Okay, let's go to the defense attorney. So how effective is the fight or flight argument, do you think, under the law?
You know, when the state tells you just to rely on the video, the defense comes in with an expert who says, but wait, we're all human beings and everyone is going to respond differently based on a fight or flight response. And in this case, we're dealing with an aggravated robbery and the trauma surrounding that. And also they point out, they talk about how little time Tony Earls had to make decisions and to respond to what was in front of him. And so the fight or flight expert came in to really humanize Tony Earls and his wife in the critical seconds that it took to shoot into the vehicle that resulted in the death of Arlene Alvarez.
Okay, and this whole trial is over if he's going to be convicted of manslaughter. Let's talk about if we do hear a guilty verdict, what does that carry in the state of Texas? And also on that note, what do you think is the strongest piece of evidence as the jury tries to decide how they are going to say guilty or not guilty here in this trial?
Well, so this is a second-degree felony, manslaughter, and so the range of punishment is anywhere from probation, a minimum of 2 years in prison, up to 20 years in prison, and of course a fine. So if we get a guilty verdict from this jury, we don't know whether the judge or the jury is going to determine punishment, but we would go right into a punishment phase where we would then decide what the appropriate punishment is within that huge range for Tony Earls in this case.
You've been following this trial very closely since it all happened in 2022. Leading up to the trial, has anything surprised you in court since it all started last week?
You know, everything has surprised me about this trial. It's funny. One, I was surprised yesterday when the defense closed with their with their expert, and that we didn't hear from the state's expert to rebut what the defense expert said in the room. I was also surprised we didn't hear from Miss Alvarez's mother, and I was surprised that we didn't hear from either Tony Earls or his wife to really humanize and get the jury to understand better what they were going through that night. But the interesting thing about having very experienced veteran lawyers in the room is that anything can happen and you should expect the unexpected. And in this case, we've had a lot of that going on for 4 days, and not to mention all the pre-trial back and forth. So when you have aggressive advocates on both sides, I think a lot of what happens surprises you because you just don't see this kind of thing happening all the time down at the Harris County Courthouse.
No, you certainly don't. So let's talk about Tony Earls not taking the stand. What do you think the strategy really was there behind it?
Well, it's difficult to know. It's inside baseball, but a lot of times it just does not benefit defense to put their client on the stand because he's not sophisticated, et cetera, because he will be cross-examined by experienced prosecutors. There's a lot of things that go into that. But in this case, and important to know, I know that self-defense is going to be one of the instructions requested by defense counsel. And the defendant does not have to take the stand in order to get that instruction. And so if it wasn't necessary, why would you take the risk? And so in this case, there was plenty of evidence in this trial that self-defense was part of the considerations for Mr. Earls. And also important is that the state has to disprove that he was acting in self-defense in order for the jury to find him guilty. And so that was a big issue, but not one that required Tony Earls to take the stand and testify that he was acting in self-defense on that critical night.
People were also confused as to why his wife did not take the stand. Let's talk a little bit about spousal privilege if she would have been called up.
Sure. So the state cannot call her unless she's willing to waive the spousal privilege, which she has, not to testify about things that her and her husband have talked about. In this case, I was surprised to see that the defense did not call his wife, who could have testified about what she went through that evening, about how scared she was, how she had a gun put in her face, et cetera. And, you know, maybe they thought they didn't need it in this case. Maybe it was something that would distract the jury. Maybe they wanted to keep this case really tight. I mean, 4 days is not very long for a case that, you know, it has been this impactful here in the city of Houston and that is so aggressively pursued by the state of Texas.
I want to use that word again. You just said impactful. Gunfire was very impactful in this trial so far. We saw an overlay of 2 videos where the gunfire also synced up with some separate video. We've heard conflicting testimony about gunfire. So how do attorneys usually address that in closings?
So it's tricky. In this case, I think the state keeps reiterating that you don't see a muzzle flash from the aggravated robbery suspect, so he's not shooting, and that he, even if he was shooting, that Tony Earls was not in a vantage point where he could see him, therefore he would not be justified in shooting. And then you have the defense who brings in an expert and says, but wait, I can hear gunshots that are unaccounted for. And so they're going to go back and forth about that issue. But I think the central theme for the state, which was in opening and went on throughout this trial, is that Tony Earls told the 911 caller that the aggravated robbery suspect shot first. And we know that fact isn't true. And so I expect to hear the state of Texas harp on that throughout their closing argument today.
Okay, so once closings wrap up, what exactly will jurors be asked to consider in their deliberations?
So as I said, there's a jury charge conference happening right now where they're deciding what law will be presented to this jury. The judge will read the law first and then allow the state and the defense to do closing arguments. The state gets to go first and last because they have the burden of proof. Then the jury will be given those written instructions that are read in open court, and they'll go back and deliberate on whether or not, as a primary question, Tony Earls committed manslaughter. And then they will consider any defensive issues that are being presented as well in reaching an ultimate outcome, which is whether he's guilty or not guilty of manslaughter in this case.
Now, this case also touches on bigger questions about self-defense. We've talked about that for the last several days as well. And also responsible gun use. How does the law frame those types of issues?
So it's really interesting. We've talked, in studio, and I've talked with other colleagues about this case is unique to Texas and to Houston. I mean, we feel differently about gun issues than people do in Minnesota, for example. And so it does raise issues about how the law applies to cases like this, where there's a tragic death that was unintended by everyone. But at the same time, you have people here in Houston, Texas, who are concerned enough about aggravated robbery and other types of violent crime that they carry a weapon without training, that they don't have to have a concealed handgun license, which I understand Mr. Earls did not, and that they can and do shoot under circumstances where they find out later it was not their intention to hurt or kill someone else other than the person that's committing a criminal offense. And so it raises all kinds of questions about Texas law, how it's applied to scenarios that actually happen here in Houston all the time, and what the right thing to do in those circumstances might be, and of course the consequences when they end tragically.
Carmen, this was supposed to start day 5 just a couple of minutes ago. They are running late, as sometimes they do, so we have a little bit more time here. And for people who are just joining us, Carmen, you've been with us since day 1, and we talked last week about the emotional pull of all of this. That is also an angle here. Mr. Alvarez, Arlene's dad, took the stand last week for 2 days, and it was very hard to watch him up there. It was very difficult for him to answer those questions. What do you think seeing him answer those questions did for the jury?
I mean, look, this case is driven by the tragedy that was the result of a shooting towards an aggravated robbery suspect and ends in the death of a little girl. And so, a lot of people question why this case was pursued as aggressively as it was. And it's because this tragic outcome occurred. And because we have a little girl who is no longer with us as a result of Mr. Earls' actions that night. And on the other side of that, you have a lot of people who feel strongly that they might have acted similarly with unintended consequences under the same circumstances. So this case is really difficult because you really have Mr. Earls, who was a victim of an aggravated robbery along with his wife, and then you have the Alvarez family, who tragically were victims of gunfire in the streets of Houston. And the question for this jury, which cannot be easy, is who do you hold responsible for that action? Is it going to be the aggravated robbery suspect, or is it going to be Tony Earls?
Okay, so let's talk about, for argument's sake, some different possibilities as far as outcome here. Let's say Tony Earls walks today. What happens then with civil lawsuits?
So my understanding is that there is a civil lawsuit that has been filed or is being pursued by the Alvarez family against a number of actors in this case, probably not the least of which is Tony Earls. And so I don't know if they will get justice in the criminal justice system or the civil justice system, but make no mistake, everyone is paying attention to this case and considering outcomes that are unintended, such as the death of Miss Alvarez. And it's one of those things where sometimes it feels really unfair to be part of any of these systems of justice or injustice, if you want to see it that way. But this is our system. And so we hope that it works out for the best for everyone involved. It's really tricky to pick a team and say that, one side should win and the other side should lose without adding in your own personal feelings about, again, which side should win and why. The Alvarez family, no doubt, are victims, and the sympathy for them is very, very justified. But does that mean that Mr. Earls goes to prison for 20 years? I don't know. That's why we let juries decide. And here in Texas and Houston, Texas, the jury system is critical because these aren't people from Minnesota. They're Harris County residents. And so when you have a jury of your peer making decisions about what's right and wrong, we really leave it in the hands of our peers, the people who live and drive in Houston and may or may not carry guns.
And that was one of the surprising things last week when the jury was chosen so quickly, because as you just said, they are residents of Harris County, and this has made national headlines for the past 3 years. And so you and I were talking off camera last Monday about how quickly they came to a decision. What shocked you the most that was open and closed on day one there for jury selection?
Well, I was surprised because I expected there to be more of a process involving individuals who had heard about the case and couldn't set it aside, or who felt strongly about one thing or another because they'd seen it in the media. But what it tells me is that a lot of jurors were very comfortable with gun issues and media to the extent that they could set it aside and move forward. And so picking a jury in basically half a day in a case like this is unusual, but it happens. And maybe it's a testament to the lawyers who do a lot of work before the jury ever comes in for selection, as well as the judge who, controls the room well. But I think it's interesting that we picked a jury so quickly. And to that point, I will tell you, having been in the courtroom, a majority of this jury are men. And so I'd be interested to see whether that plays a role in their deliberations and how that may impact the way that closing arguments are presented today.
Yes, because this is a very emotional trial, as we've been saying, and usually that favors for women jurors. That's something that they care more deeply about, and it could possibly sway their decisions. Now, you just mentioned the lawyers here. Let's get into that for people just joining us. We have John Jordan, and then we also have Anthony Oso, very high-profile attorneys here in Harris County. What are your thoughts about why they both took this case?
Well, I think that John Jordan is a very passionate prosecutor. I think he takes cases because he believes in them, and the work in the room that you see is a testament to that. I think he cares very deeply about this case and the outcome. I think Anthony Oso, who's very well known in the legal community, he's been doing this type of work for a very long time. He handles capital murder cases, very difficult cases involving life and death. And so I expect that he feels just as strongly about representing Mr. Earls and making sure that he receives a fair trial and that he has good defense counsel representing him, so that those issues of self-defense, which are always fascinating, can be adequately presented both factually and legally.
Okay, and Carmen, they are still running a bit late. So as we close here, let's talk about what you think the strategy is going to be from both sides when they do their closing arguments.
It's difficult to say because both sides have impressed me and confounded me throughout this trial. There's a lot you don't expect and plenty that you're impressed by. But I expect that the state of Texas is going to really hammer home the impact this shooting has had on the Alvarez family. I think they're going to talk a lot about reckless and how, shooting into a vehicle where you can't see inside the vehicle and you're not reasonable in thinking that this aggravated robbery suspect was in the vehicle is going to be the center of their argument. I think they're going to focus on the videos that they have spent a lot of time preparing to present to this jury and encourage them to take them back into deliberations. From the defense side, like I said, they may be asking for a lesser included offense, but I think they're going to focus their time on self-defense and what is it, return of property. And those are both very well structured in the law in the state of Texas. And so I think that has been their central theme. And I think they're going to talk a lot about how impactful, emotional, traumatic, an aggravated robbery really is, and the less than 2 seconds that Tony Earls had to respond. And that while it was something that had unintended consequences, that a reasonable person in his situation likely would have done the same thing. And then, go from there. But I think that both sides are going to be very aggressive. I think they're both going to be very dramatic today because look, this is what all the marbles are about for them. They have worked for years, as you pointed out, on this case and trying to get what they perceive justice is from both perspectives. And so it'll be really interesting to see how long it takes this jury to resolve these very difficult issues as we watch closing arguments today.
We have been watching for the last 20 minutes or so Tony Earls. The camera has been close up on his face, as it has been since this started just last week, right before we hear the all rise. He was very emotional on day one and day two. Today, looking at that, Carmen, I know you can't see, but we're watching him. He appears to be much more composed. What does that play as far as a role in jurors when they see his face?
And Steph, I can see him, and you're absolutely right. He's been very emotional. He's had his head down. And I think that's been important throughout this trial for the jury to see what I perceive to be remorse from him or some level of acceptance of responsibility and how difficult this case has been for everyone involved, really. Today, he does look more composed, and it looks like, and I would expect that he's ready to move forward like this. You can't imagine being in his position. These lawyers are staying up until midnight or 2 a.m. and getting up at 5 every morning, working hard. It's exhausting. And he's been going through this for 3 years, 3 years of threats of going to prison, 3 years of his whole life could be over, et cetera, et cetera. And I think it's exhausting. I think today he may just be looking to get some level of resolution so he can move forward with his life. And that's what I see on his face today.
Carmen, we know you're going to be watching this day very closely, as are we. And once again, we do have our Agochi Loca and Anieli Ruiz in the courtroom. They will have reports throughout the day. And Carmen, we will most certainly hear from you again, probably later today and also tomorrow. We always appreciate your legal perspective. Thank you so much for joining us. And we are going to go inside the courtroom now with a live look as we wait for the all rise. It was supposed to happen 13 minutes ago. Hopefully it happens shortly. Thank you for watching.
I don't know. We'll figure it out. That's 30. I don't know. We can figure it out. I don't know. Y'all may be seated. At this time, ladies and gentlemen, I'm going to read you the charge of the court containing the law applicable in this case. Please remember my admonishments about communicating about the case. This is the charge. You're going to have it in the room with you to look at. So I know sometimes juries, when I'm reading it to them, they're like trying to like understand it really quickly, but you will have possession of this charge, okay? I just want you to hear it from me, the charge in itself. In cause number 1926763, State of Texas versus Tony Earls, in the District Court in Harris County, Texas, the 182nd Judicial District Court, jury charge. Members of the jury, the defendant, Tony Earls, is accused of committing the offense of manslaughter. The defendant has pleaded not guilty, and you have heard all the evidence. The parties will soon present final arguments. Before they do so, I must now give you instructions you must follow in deciding whether or not the state has proved the defendant guilty. You will have a written copy of these instructions to take with you and use during your deliberations. I will first tell you about some of the general principles that apply in all criminal cases. Then I will tell you about the specific law applicable to this case. Finally, I will instruct you on the rules that must control your deliberations. The indictment. The indictment is not evidence of guilt. The indictment is a document required to bring the case before you. Do not consider the fact that the defendant has been arrested, confined, or indicted, or otherwise charged. Do not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless the state proves each element of the offense beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient for you to return a verdict of not guilty. You may find the defendant guilty only after careful and impartial consideration of all of the evidence, and only if the state has proved the defendant's guilt beyond reasonable doubt. Burden of proof. The state has the burden of proof in every element of the offense beyond a reasonable doubt. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If it does not, then you must find the defendant not guilty. If, after you have considered all the evidence and the instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. Jury as fact finder. As the jurors, you will review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. Evidence. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not in evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with the case that is not evidence in the trial. Statements made by lawyers are not evidence. The questions asked by the attorneys are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of the case or influence you to vote one way or the other. You should give terms their common meanings unless they have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony, and exhibits of those inferences are justified in light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to determine by bias or prejudice. Admitted exhibits. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibits you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Testimony. Certain testimony will be read back to you by the court reporter if you request. To request that testimony to be read back to you, you must follow these rules. The foreperson must make the request in writing and sign. The request must, number one, state that it is requesting that testimony be read back. Number two, state that you have a disagreement about a specific statement of a witness or a particular point in dispute. And number three, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in dispute. The verdict. The law requires that you render a verdict of either guilty or not guilty. The verdict of not guilty simply means that the state has not proved the defendant's guilt beyond reasonable doubt. You may return a verdict only if all 12 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. Next topic, defendant's right to remain silent. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him, and it is not evidence of guilt. In this case, the defendant has chosen not to testify. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand or why he did not. The foreperson of the jury must immediately stop any juror from mentioning that the defendant's decision not to testify. The law specific to this case. The state has accused the defendant of committing the offense of manslaughter. Relevant statutes. A person commits the offense of manslaughter if the person recklessly causes the death of an individual. Definitions. Recklessly causing the death of an individual. A person recklessly causes the death of an individual if there, number one, if there is a substantial and unjustifiable risk that his conduct will cause that death. Number two, the risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the person's standpoint. And number three, the person is aware of but consciously disregards that risk. Application of law to the facts. If you find from the evidence beyond a reasonable doubt that the defendant Tony Earls in Harris County, Texas, on or about February 14th of 2022, recklessly caused the death of Arlene Alvarez by discharging a firearm in the direction of an occupied motor vehicle while making no effort to determine the identity of the occupant of the motor vehicle and shooting Arlene Alvarez with the firearm, you will find the defendant guilty of the offense of manslaughter. If you all agree that the state has failed to prove beyond a reasonable doubt these above facts, you must find the defendant not guilty. If you all agree that the state has proved beyond a reasonable doubt all of the elements of the offense as set forth above, you must next consider whether the defendant is not guilty because his use of force was justified by the defense of self-defense, defense of third person, and defense of property. Reckless injury of innocent third person. Before considering whether the defendant is not guilty because his use of force was justified by self-defense, defense of a third person, or defense of property, you must first consider whether those particular justifications are available to the defendant. Even though a person is justified in threatening or using force or deadly force against another, if in doing so he recklessly injures or kills an innocent third person, the justifications of self-defense, defense of a third person, and defense of property are unavailable in a prosecution for the reckless killing of an innocent third person. Therefore, in this case, if you find beyond a reasonable doubt that the defendant recklessly injured or killed an innocent third person, the justifications of the self-defense and defense of property are not available to the defendant. If you have found beyond a reasonable doubt that the defendant recklessly injured or killed an innocent third person, you should proceed to that portion of the instructions titled Rules That Control Your Deliberations and render a verdict based on the facts and the law that I have given you. Self-defense. A person's use of deadly force against another that constitutes the crime of manslaughter is justified by self-defense. Number one, when the person reasonably believed that the degree of force used was immediately necessary to protect the person against the other's use or attempted use of unlawful deadly force, or number two, when the person reasonably believed that the degree of force used was immediately necessary to prevent the other person's imminent commission of robbery or aggravated robbery. Self-defense does not cover conduct in response to verbal provocation alone. The defendant must have reasonably believed that the other person had done more than verbally provoke the defendant. Presumption. A person's belief that deadly force was immediately necessary is presumed to be reasonable if the person, number one, knew or had reason to believe that the person against whom the deadly force was committing or attempted to commit the offense of robbery or aggravated robbery. Number 2, did not provoke the person against whom the deadly force was used. And number 3, was not otherwise engaged in criminal activity other than a Class C misdemeanor that was a violation of the laws or ordinance regarding traffic at the time of the deadly force was used. The presumption applies unless the state proves beyond reasonable doubt that the facts giving rise to the presumption do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, you must find that the presumed fact exists. Even though you may find that the presumed fact does not exist, the state must prove beyond a reasonable doubt each of the elements of the offense of manslaughter. If you have a reasonable doubt as to whether the presumed facts exist, the presumption applies, and you must consider the presumed fact to exist. A person who has a right to be present at the location where the deadly force was used, who has not provoked the person against whom the deadly force was used, and who is not engaged in criminal activity at the time that the deadly force was used, is not required to retreat before using deadly force. In determining whether such a person reasonably believed that the use of deadly force was necessary, you may not consider whether the person failed to retreat. Burden of proof. The defendant is not required to prove self-defense. Rather, the state must prove beyond a reasonable doubt that the self-defense does not apply to the defendant's conduct. Definitions. Reasonable belief. Reasonable belief means a belief that an ordinary and prudent person would have held in the same circumstances as the defendant. Deadly force. Deadly force means force that is intended or known by the person using it to cause a death or serious bodily injury, or force that in the matter of its use or intended use is capable of causing death or serious bodily injury. Robbery. Robbery is intentionally or knowingly threatening or placing another person in fear of imminent bodily injury or death while in the course of committing theft and with the intent to obtain or maintain control of the property. Aggravated robbery. Aggravated robbery is committing robbery and using or exhibiting a deadly weapon in the course of committing theft. In the course of committing theft, that means conduct that occurs in an attempt to commit during the commission or immediate flight after the attempt or commission of theft. Theft is the unlawful appropriation of property with the intent to deprive the owner of the property and without the owner's effective consent. Application of the facts. If you have found beyond a reasonable doubt that the defendant committed the offense of manslaughter as set forth above, but you find further that, number 1, A, the defendant believed that his use of force was immediately necessary to protect himself against the unknown robber's use or attempted use of unlawful deadly force, or the defendant believed that his use of force was immediately necessary to prevent the unknown robber's imminent commission of robbery or aggravated robbery, and the defendant's belief was reasonable. The state has the burden of proof to reject the justification of the defendant's conduct based upon self-defense. The state must prove beyond a reasonable doubt that the defendant cannot rely upon the justification of the self-defense. The state must prove to you beyond a reasonable doubt that the defendant cannot rely upon the justification of self-defense based upon an examination of the two elements set forth above. If you find that the defendant cannot rely upon the justification of self-defense, you may next determine if the defendant's use of force was justified by the defendant of a third person. If you find that the state has not satisfied its burden of proof to reject the justification for the defendant's conduct based upon self-defense, you must find the defendant not guilty. Defense of a third person. A person's use of deadly force against another that constitutes the crime of manslaughter is justified by the defense of another person if, number 1, the person reasonably believed another was using or attempted to use unlawfully deadly force against a third individual. Number 2, under the circumstances as the person reasonably believed them to be, the third individual would be entitled to defend herself against this unlawful deadly force. And number 3, the person reasonably believed that his intervention was immediately necessary to protect the third individual from the unlawful deadly force. Whether a person is permitted to use force or deadly force to protect himself against unlawful force is determined by the law of self-defense. Under the law of self-defense, a person is entitled to use deadly force to defend herself if the person reasonably believes, number 1, another was using or attempted to use unlawful deadly force against the person, and number 2, the person's conduct was immediately necessary to protect himself against the unlawful deadly force. Burden of proof. The defendant is not required to prove that the that the defense of a third person applies to this case. Rather, the state must prove beyond a reasonable doubt that the defense of a third person does not apply to the defendant's conduct. Definition: reasonable belief. Reasonable belief means a belief that an ordinary and prudent person would have held in the same circumstances as the defendant. Application of law to facts. If you have found beyond a reasonable doubt that the defendant committed the offense of manslaughter as set forth above, but you further find that, number one, the defendant reasonably believed that the unknown robber was using or attempted to use unlawful deadly force against Deanna Hines, or number two, under the circumstances as the defendant reasonably believed them to be, Deanna Hines would have been entitled to defend herself against this unlawful deadly force, and number three, the defendant reasonably believed that his intervention was immediately necessary to protect Deanna Hines from the unlawful deadly force. The state has the burden of proof to reject the justification of the defendant's conduct based upon the defense of a third person. The state must prove beyond a reasonable doubt that the defendant cannot rely upon the justification of the defense of a third person. The state must prove to you beyond a reasonable doubt that the defendant cannot rely upon the justification of defense of a third person based upon an examination of the two elements set forth above. If you find that the defendant cannot rely upon the justification of defense of a third person, you must next determine if the defendant's use of force was justified by the defense of property. If you find that the state has not satisfied its burden of proof to reject justification for the defendant's conduct based upon the defense of a third person, you must find the defendant not guilty. Defense of one's own personal property. A person's use of deadly force against another that constitutes the crime of manslaughter justified by the defense of property if the person reasonably believed, number one, the person was lawful possession of tangible, movable property. Number two, another person was unlawfully interfering with that property. Number three, the deadly force used was immediately necessary to prevent either A, the other's imminent commission of robbery or aggravated robbery, or B, the other who was fleeing immediately after committing robbery or aggravated robbery from escaping with the property, and number four, either A, the property could not have been protected or recovered by any other means, or B, the use of force other than deadly force to protect or recover the property would have exposed the person or another to a substantial risk of death or serious bodily injury. Burden of proof. The defendant is not required to prove that the defense of property applies to this case. Rather, the state must prove beyond reasonable doubt that the defense of property does not apply to the defendant's conduct. Definitions. Reasonable belief. Reasonable belief means a belief that an ordinary and prudent person would have held in the same circumstances as the defendant. Deadly force. Deadly force means that it is intended or known by the person using it to cause the death of serious bodily injury, or force that in the matter of its use or intended use is capable of causing death or serious bodily injury. Robbery. Robbery is intentionally or knowingly threatening or placing another person in fear of imminent bodily injury or death while in the course of committing theft and with the intent to obtain or maintain control of the property. Aggravated robbery. Aggravated robbery is committing robbery and using or exhibiting a deadly weapon in the course of committing theft. In the course of committing theft means conduct that occurs in an attempt to commit during the commission or immediate flight after the attempt or commission of theft. Theft. Theft is the unlawful appropriation of property with the intent to deprive the owner of the property and without the owner's effective consent. Application of laws to the fact. If you have found beyond a reasonable doubt that the defendant committed the offense of manslaughter as set forth above, or you further find that, number one, the defendant was in lawful possession of the tangible movable property. Number two, the unknown robber was unlawfully interfering with that property. Number three, the defendant reasonably believed that his use of deadly force was immediately necessary to prevent either A, the unknown robber's imminent commission of robbery or aggravated robbery, or B, the unknown robber who was fleeing immediately after committing robbery or aggravated robbery from escaping with the property, and number four, the defendant reasonably believed either A, the property could not have been protected or recovered by any other means, or B, the use of force other than deadly force to protect or recover property would have exposed the defendant or another to a substantial risk of death or serious bodily injury. The state has the burden of proof to reject the justification of the defendant conduct based upon the defense of property. The state must prove beyond reasonable doubt that the defendant cannot rely upon this justification of the defense of property. The state must prove to you beyond a reasonable doubt that the defendant cannot rely upon the justification of the defense of property based upon an examination of the 4 elements set forth above. If you find that the defendant cannot rely upon the justification of the defense of property, you must find the defendant guilty of the offense of manslaughter. If you find that the state has not satisfied its burden of proof to reject a justification for the defendant's conduct based upon the defense of property, you must find the defendant not guilty. Rules that control your deliberations. You must follow these rules while you're deliberating and until you reach a verdict. After closing arguments by the attorneys, you will go into the jury room. Your first task will be to pick a 4-person. The 4-person should conduct the deliberations in an orderly way. Each juror has 1 vote, including the 4-person. The 4-person must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. You must not discuss the case with any court officer or the attorneys or anyone not on the jury. Number 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all y'all are present again. Number 3, you must communicate with the judge only in writing, signed by the 4-person, and given to the judge through the officer assigned to you. Number 4, you must not conduct any independent investigations, research, or experiment. Number 5, you must tell the judge if anyone attempts to contact you about the case before you have reached your verdict. Your sole duty at this point is to determine whether the state has proved the defendant guilty. You must restrict your deliberations to this matter. After you arrive at your verdict, you are to use the form attached to these instructions. The 4-person should sign the line that corresponds to your verdict. After the closing argument by the attorneys, you will begin your deliberations. And I missed it here, but signed by Judge Anil Lakai of the 182nd. I'll go ahead and sign it. Next sheet. There's a verdict form. Option number 1, verdict, not guilty. We, the jury, find the defendant Tony Earls not guilty. Place for the foreman of the jury to sign. Place for the foreman of the jury to print. Verdict. Other option, verdict, guilty. We, the jury, find the defendant Tony Earls guilty of the offense of manslaughter as charged in the indictment. Space for the foreman of the jury to print. Space for the foreman of the jury to sign as well. With that said, again, you will receive this form with y'all when y'all start deliberations. Each side has 45 minutes. The state of Texas has opted to go first and then go last since it is their case. And when you start speaking, I'll start my timer, sir.
Thank you, Your Honor. Good afternoon, everybody. What the judge just read to you is called the jury charge. He's going to give you a copy of it. But essentially, it's the law in this case that's going to apply to your deliberations. And then each portion or section of the law that's explained in here has what we call an application paragraph. It explains how you apply the facts and the evidence that you've heard during this trial, whether it's testimony or video, and how it applies to this case. So it's just guiding you in your deliberations. And we're going to talk about the charge here in a moment. I mean, it's 21 pages long. You guys sat here for a bit while we were reading it. We'll talk about it here in a moment, but first I want to talk to you about a couple of things. When I'm done speaking, the defense will have the opportunity to speak to you, and then you will hear from Mr. Jordan last. That's because the state has the burden of proof. So the law says that we talk first and then we talk last. But one of the things I wanted to talk about before we get started is we've heard a lot of testimony over the last couple of days. The law is complicated, but it's actually pretty simple. Why? Because look at your fellow jurors around you. Each one of you has a different profession. Each one of you lives in a different part of town. Each one of you has a different background. But every one of you is a member of our community. Every one of you is a member of Harris County. And together, the 12 of you, the 14 of you even, represent our community. The one thing that we're asking is don't leave your common sense at the door. Don't leave all the things that you know in your gut and your instinct tell you at the door. Apply the facts to the law, but don't leave your common sense at the door. The next thing I want to talk to you about is the law itself. Okay? The defendant is charged with the offense of manslaughter. A person commits the offense of manslaughter if the person recklessly causes the death of an individual. This is on page 6 of your jury charge. The question is the defendant aware of a substantial and unjustifiable risk, and does he consciously disregard that risk? Because here's the thing, ladies and gentlemen, no one in this courtroom is going to dispute that he shoots into a car and kills Arlene Alvarez. Not a single person in this courtroom is going to dispute that. They're just going to ask you to find that his actions and conducts are justified. They want you to believe that her death, his actions that caused her death, are justified. So the question is, when he gets out of the car and he shoots at the robbery suspect in the back 3 times, we know it's not self-defense. Their own expert testified to it yesterday. You have to be immediately necessary to perceive the unjustifiable use of deadly force. The guy's got his back turned away. We'll get to self-defense here in a moment. The question is, when he is shooting into the car, shot number 4, shot number 5, shot number 6, shot number 7, shot number 8, shot number 9, shot number 10 down the street, is he aware of the risk that he's going to shoot and kill somebody in that car? Absolutely. Is he aware when he takes shot number 4 and he takes shot number 5, is he making a conscious decision to disregard that risk? Absolutely. Your common sense tells you that. You don't need a homicide investigator to tell you that. You're watching him do it on video. Mr. Jordan made a very specific and clear point to you guys. You're a unique jury because we can't take you to the crime scene, but we sure did bring it to you. And we'll go over that here in a bit. The next question you have. So first is his risk. Is there a substantial and unjustifiable risk, and did he consciously disregard it? If the answer is yes, he is guilty of manslaughter. Now, this reckless injury of an innocent third person, it's on page 7 of your charge, okay? What this law says is before you get to self-defense, before you get to defense of a third person, before you get to defense of property, you have to answer this question. And you will see that that is exactly how it's laid out in your charge. Is he guilty of manslaughter? Did he recklessly kill an innocent third person? If the answer to this question is yes, you don't go to self-defense. If the answer to this question is yes, there is no defense of a third person. If the answer to this question is yes, there certainly isn't defense of property. And that's what the law says. Before considering whether the defendant is not guilty because his use of force was justified by self-defense or defense of property, you must consider whether those particular justifications are available to the defendant. So even though a person is justified in threatening or using deadly force against another, if in doing so, if he's justified and he's using deadly force, he recklessly injures or kills an innocent third person, self-defense and defense of property are not available in the prosecution for the reckless killing of an innocent third person. So you don't even go to self-defense. Before you consider defense of a third person, before you consider defense of property, if the answer to that question is yes, if shot number 4, shot number 5, 6, 7, 8, 9, 10, he's consciously disregarding a very unjustifiable and substantial risk of shooting into a vehicle and killing someone, he's guilty of manslaughter. And there's a reason why this is on page 7, because if you get here and the answer is yes, you move to the back page and you sign the verdict form. That's why self-defense is on page 8. Your answer should be yes, and you should not move to page 8. But let's just say, because we know that they're going to get up here and argue, in voir dire, they're not required to tell us what their strategy is. In voir dire, they're not required to tell us if they're going to put on evidence or not. They're just not. The law doesn't require them to.
Objection
We have the burden of proof.
shifting, objection striking at defendant over shoulder of counsel.
Then overruled. And remember what I said, I probably have this memorized. The statements by the attorneys, including opening statements, closing statements, are not evidence. Evidence comes from the witnesses and also from the testimony that you have heard. You may continue, sir. And my rule is always that you can't go past the...
Sorry, Judge.
It's okay. Just a friendly reminder.
We have the burden of proof. We have the burden of proving to you beyond a reasonable doubt that he is reckless when he shoots into a car that he can't see into. We have the burden of proof that he loses sight of the robbery suspect, and then Alvarez's truck comes down the road, the next thing catches his eye, and he's just unloading into that vehicle. Now, the reason why in opening statements Mr. Jordan told you the perspective that matters is the defendant's is because that is how the law of self-defense applies. The perspective that matters isn't the China Star video across the street where you can see the assailant running by the Alvarez's car, because he wouldn't have seen that. Their own expert told you that. He wouldn't have seen past the chase sign. So the perspective is certainly not when the robbery suspect is running down the street and he has his arms stuck out, right? Because the defendant wouldn't have even seen that. The defendant, as it pertains to self-defense, the question is there a immediately necessary reason to respond to the use of unlawful deadly force to prevent the other person's imminent commission of an offense? To prevent the imminent commission of an offense. So, look, Mr. Taravella, their own witness, admitted it. When the robbery suspect has his back turned, not self-defense when he shoots shot number 1. We all know in Texas, you can't shoot a person in the back and then claim self-defense. You just
Objection,
can't.
that's a misstatement of the law.
The law is in the jury charge. Refer to your jury charge.
If a person is running away from you after they've committed an offense, you can certainly shoot at their back to get your property back, but you can't shoot at their back and use deadly force unless you're presented with the imminent use of deadly force. Their own expert, I asked him very specifically, first shot, self-defense, yes or no? Nope. Second shot, self-defense, yes or no? Nope. Third shot, self-defense, yes or no? Nope. Fourth shot, self-defense, yes or no? Oh wait, the fourth shot, the one where in State's Exhibit 108, that video we compiled, remember that one? We talked about it with Zachary Caldwell. You guys remember that video? That video shows you the sound frequency of shot number 4 is the same exact sound signature as shot number 1, as shot number 2, as shot number 3, as shot number 5, as shot number 6, shot number 7, and shot number 8, and shot number 9. Their own expert said shot number 4 sounds exactly like every other gunshot that man fired that night. You don't need a homicide detective to tell you what it sounds like. We know what they're going to get up here and argue. They're going to say, CSU could have collected more shell casings. Mr. Jordan told you that in opening statement. He told you what we're going to present to you. He told you they didn't find 10 rounds, but beyond a reasonable doubt, you will know he shot 10 times. Their own expert admitted it. He told you they found the casings next to the grate and a couple next to the ATM, and that's exactly what the evidence showed. He told you that the trajectory at which the gunshot is fired is perpendicular to the vehicle, and that's exactly what the experts testified to. They called Andrew Taravella, a crime scene reconstructionist who sat on this stand right here. and didn't testify to anything that Chelly Rossi testified to, our reconstructionist, but instead went to a field he's never been certified as an expert in, never testified as an expert in, and wanted to comment on surveillance video that was compiled by an actual licensed digital forensic analyst. Notice how I kept asking him, you keep saying that those tapping sound is gunshots, but you keep using the words, I believe they're gunshots. Are they gunshots or not? And his response was, well, I can't say that they're gunshots. Regardless of the fact, the defendant's already started shooting at the back of the robbery suspect. Regardless of the fact, when he sees a vehicle coming down the roadway and the windows are up and the vehicle is tinted and he cannot see a firearm at that moment, we know he's not in fear of deadly force being used against him. He's the one that's running into the middle of the grassy area and shooting at a car that he can't see into. We're not asking you to leave your common sense at the door. You guys are reasonable. What would a reasonable person do? You guys are reasonable. Don't leave your common sense at the door. What would a reasonable person do? And it's not self-defense from the perspective of the defendant. No. The law specifically says a reasonable belief means a belief that an ordinary and prudent person would have held in the same circumstances as the defendant. This is why this is important. In opening statements, they told you the robbery suspect and Tony Earls exchanged gunfire. That's what they told you. They told you that when Tony Earls gets out of the vehicle to pick up his keys, he gets shot at. Not true. The video evidence tells you that. It's just not true. He gets out of the car and he lets off 3 rounds in the direction of a man that's fleeing with his back turned to him. And you can tell that from a surveillance video. Same way you can tell he shoots 10 times. You don't need 10 cartridge casings to tell you that. We watched it on the video. State's Exhibit number 108. Go back in the back, watch that 3 times, start your deliberations. You won't spend too much time past page 7. But here's the thing. Self-defense is from an ordinary, prudent, reasonable person in the circumstances of the defendant. Not the defendant, but an ordinary, reasonable person. So then the question becomes, okay, well, is he trying to get his property back? Because I asked Mr. Tarabella that. Well, shot number 1, the law in Texas does allow you to shoot somebody in the back as they're fleeing away to get your property back. Shot number 2, he's justified in regards to defense of property, not self-defense. Shot number 3, defense of property. Definitely not self-defense. Definitely not past page number 6 if you believe that there was a substantial unjustifiable risk and he had a conscious disregard for that risk and he killed an innocent third party. You don't even get to the self-defense questions. But let's talk about shot number 4, shot number 5, 6, 7, 8, 9. He's trying to defend his property by shooting into a vehicle that you can't see into. Don't leave your common sense at the door. Shot number 10, he points his firearm, and their own expert actually said it. He points his firearm as the vehicle is moving. He's already dropped his phone and his keys and picked them both back up. He's now in a moving vehicle. He opens the door to the vehicle. He sticks a gun out, and he shoots into the middle of an intersection, dropping his phone and his keys that he just picked up. And I asked Mr. Taravella, he shot into the middle of an intersection. And their own expert said, actually, I don't know where he shot. What do you mean you don't know where he shot? You said he went to the crime scene. Is there an intersection after that frame or not? He said, yeah. I was like, the reason you don't know where he shot is because he could have been shooting at Armando Alvarez as he's standing outside of the car. He could have been shooting at the vehicle when it has its brake lights stopped, flashing in his direction. And then he peels off after shooting and he goes in the opposite direction. They want you to believe that it was reasonable and he was trying to get his property back. before you get to self-defense, before you get to defense of a third person, before you get to defense of a property, if you believe beyond a reasonable doubt that there's a substantial and unjustifiable risk that if you shoot into a car, you're going to kill a person, especially if you can't see into it, or he has the conscious, objective disregard for that risk when he turns that gun on gunshot number 4, and Armando and Wendy Alvarez are looking at this man shooting into their vehicle on the way to go get pizza with their 9-year-old daughter in the back seat, he's guilty of manslaughter. And if he kills an innocent third party, if you believe he killed Arlene Alvarez because he was reckless about the way he's even handling the firearm that night, shooting with one hand, jumping around, you don't go to self-defense. You don't entertain defense of a third property. And you certainly don't entertain defense of a third person. Don't leave your common sense at the door. The 12 of you are reasonable. The 12 of you are members of Harris County. And at the end of closing arguments, you're going to start your deliberations. And in one voice, you will render one verdict that is one word: guilty.
May I proceed, Your Honor?
Sure, just look at this thing. Give me 1 second. 26 minutes and 25 seconds left. Give me 1 second. Let me start your timer also. I'm a little confused. You wanted me to do 3 reminders?
I'm sorry, Your Honor. What were you asking me?
You wanted to do 3 reminders? How much time did you want? Or you
No,
messing?
I just want to, give me like a minute at 9. I'm just want to.
Oh, okay, you just wanna get it.
That's all. 10, 11. I'm not.
I'll tell you when you're used 10 minutes and then
That's
just
fine.
switch.
Judge, I just want to make a
Okay.
few points here.
Okay, go ahead.
Good morning, ladies and gentlemen of the jury. Listen, I was thinking this morning about what I would say to you, and I'm going to start out because I knew this was coming. 42 years, 43, I've been doing this. These are seasoned, okay? Make no mistake about it. And I was anticipating their theatrics, and believe me, there's going to be more to come. Raising your voice, pacing, ranting, raging, that's not evidence in the case. So I'm going to talk to you, something I typically don't do. I'm actually going to keep my voice down and kind of walk through a couple things I just want to encourage you to talk about when you're there, because Mr. Maroon, you know, he talks about what he thinks the evidence is and how our client didn't do this and he didn't do that. So let me start out with, I want to turn on and talk to you about a couple of things. Remember when Rossi was on the stand and I walked up with the code and I asked her to review what a prosecutor's duty is? Remember when she agreed with me that the prosecutor's primary duty is not to seek a conviction? Okay, that's not the primary duty. It's to see that justice is served. And make no bones about it, Arlene deserves justice. Okay, she does. Thankfully, we know from the evidence in this trial that if and when they ever prosecute the suspect who started this whole series of events in motion, they have video of him. You saw him robbing Tony and his wife. You saw him running. You saw him jumping over a fence. At the very end, they put that up. Clearly, after all of this had occurred, you see this guy climbing over the fence, and they have a pretty good shot of him. I can't tell you how they'll prosecute that person and what arguments they'll make to his jury, but I can talk to you about the evidence in this case. And here's the thing. We talked about how you don't secret evidence. Okay, you put it all out there. You let the juries decide. And here's what I hope some of you want to get the discussion going on in deliberations, is that we spent hours and hours and hours of listening to them talk about the what. Well, we all knew the what. We told you the what up front. Tony shot into the truck, okay? But we had to listen to angles. We had to listen to all the scientific evidence. But if you notice, what they brought you was people who either worked for their office, okay, or someone who works for the Montgomery County's District Attorney's Office, okay? But we didn't hear from some critical people, and let's talk about that. I want to put the overhead up. Well, the first thing I want to talk to you about is, well, it was here, but it's that little USB that has State's Exhibit number 108 in it. Now, no, it's obvious through this trial that this is the techie. This man and Zach Caldwell, they are the techies. I don't profess to be a techie. I can't make digital exhibits. I'm the guy, probably the only person here who's still writing on a yellow legal pad. Okay? But if you recall, okay, Zachary Caldwell gets on the stand and they're going to play, I'm sure we're going to see it, it might be part of the theatrics, put it in slow motion and show the call-outs, the call-outs, the call-outs. Boom, boom. It didn't happen. It happened real fast. Now, I don't know if it's deliberate. Maybe it's an oversight. I don't know. Okay, I can't tell you which one because I'm not in their heads. And maybe they can just say Zachary Caldwell decided to leave out the 5 shots, and let's talk about that because Andrew was pretty straight up. Okay, for 35 years on the police force, he's heard gunshots. Okay, so he said. He kept asking him, are they gunshots? And he goes, well, in my opinion, I believe they were gunshots, okay? And so as I walked back, I even pointed out that Rossi, their expert, the woman is an expert in almost everything, but she was still in the courtroom hearing that. And I said, basically asked them, get him repeated because they would have the ability to rebut with her. They could put her back on the stand. Here's what they didn't do, though, okay? Whoever did it, whether Caldwell or whoever instructed, whenever they talked about, they intentionally left it off the call-outs. And I'm calling them out on it because we showed you A, B, C, and D, if I can publish this, shows that the call-outs would have registered. And if you wanted to do an accurate compilation, then A, B, C, and D would have been on it, okay? Now, if you notice, we closed. They didn't call Rossi back. They didn't address the call-outs that they eliminated from that State's 108 exhibit. They could have called her back and she could have said, in all my years, and all my experience, and all my education, I think we heard about everything she did since kindergarten. But we stipulated she's an expert, and she didn't dispute the fact that those were gunshots. They didn't address it straight up, okay? Nor did they address it after the fact, okay? And so that is, it's kind of a misleading exhibit, okay? I'm gonna use that word. It misleads the jury. You get to consider, and we've said it all along, you got to consider the why. Okay, the why. And he made reference to, we don't need to bring a detective here. Well, let me show you a couple things too that I think you should talk about, and hopefully someone will bring it up. And listen, a lot of the theatrics and a lot of the walking around and the yelling and moving up close to the jury, everybody here, they're good lawyers. I like to think I'm a good lawyer, okay? I'm going to try to keep my voice down, but they make emotional arguments to incite emotion. And if you get back there and you keep talking about the emotion, look, it's a tragedy, man. I can't even comprehend what it must be like for the family, all right? The foreman, whoever you are, or she is, whoever becomes the foreman, it's going to be your job to say, look, we can't use prejudice or bias or emotion. Let's look at the facts, and let's look at all the facts, the totality of the circumstances, okay, when we're deciding. So quickly, because I don't want to use all of the time, but State's Exhibit number 23. Look, I think they even agree it was the worst, one of the worst investigations you'll ever see as far as collecting the evidence. I mean, he couldn't even identify these two guys in the suits that are talking there. We know from the facts in this case that the one guy on the left, if you can compare, look at his head, we know that he's the same person who interviewed Tony Earls, okay, in this exhibit right here. Here's Tony being spoken to by the detective. And Andrew said 35 years I've been doing this, and it's not routinely we call a detective. So there's two things that they kept from you. They kept from you the detective's opinions, of whatever they may have been from the case, about what he felt, the guy who was out there that night, okay? And they're gonna tell you, oh, they could have called him. Well, we don't have the burden of proof, they do. So look at it, look at the fact and consider the fact that that's, you know, something they kept from you, okay? And then the fact that our client gave a statement. He's interviewed shortly following this event, and here's what this shows you. I mean, you can basically see his demeanor when he's speaking to the detectives, okay? Now, you know, I think even Andrew or Rossi had said, we can't introduce our client's statement into evidence, okay? We're not allowed. They can, they have it, okay? And what it tells you that it's what he's thinking, because they're obviously talking about it. So here's what they kept from you, okay? And let me say this, you got instructions. The fact that they can't call him to the stand, and I can tell him whether or not to take the stand. I'm just going to tell you that, like the judge told you in the very beginning of the trial, there's all kinds of reasons. Packed courtroom, skilled, very skilled prosecutors. You could take all kinds of things
So
into
you use 10
consideration.
minutes just to give you a heads up.
I'm sorry, I have a few
You
left.
asked me for 10 minutes. You can take as much time as you want. I'm just
Okay.
saying, you asked for 10 minutes.
I'll need just a couple more. So I think it's important to recognize that that you shouldn't just consider the what, you got to consider the why, okay? And part of the why is what he's obviously talking to the detective about. And so I hope that at least some of you are offended or moved by the fact that they kept this information from you. And you, I would encourage you, because he brought it up, use your common sense. If the detective had a favorable opinion to their case.
Objection, improper argument outside the record and false.
That'll be sustained.
Okay, well, Judge, I don't know what his opinion is. I'm just saying.
Because it's outside the record, he's not allowed to argue.
It's sustained. Please move forward,
Okay,
sir.
all right. So you don't know what his opinion was because they didn't bring it to you. You don't know what Tony Earls told them or spoke to. Maroon made an issue of it, and the language says you have to consider while making no effort to determine the identity of the occupants of the motor vehicle, while making no effort to determine the occupants, okay, of the vehicle. Well, so here's what you do: rather than just using their graphics during closing, of boom, 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 and the stills that they did with Rossi. All I ask is you do this. Talk about the speed of the vehicles, and the videos have it for real. The sound out there, including what he tried to refer to, I think, as somebody packing their cigarettes. It's probably a statement he'd like to pull back on. The sound, the sight line, and the split-second timing, and the limited lighting, okay? So when you talk about how you might have reacted or someone might have reacted, just look at all the facts, okay? As far as what he saw, we know he intersected the truck, okay? And his determination was started with being robbed, followed by the robber running in the exact direction of the truck, that going right up to the truck, and the truck emerging, okay? So he had facts to make a determination, but he had to make he made a split-second decision. So I think that he's right about one thing. You probably don't get too far into this charge because of that issue if you consider all of the facts. And I can say it for Ed, I can say it for Anna. Actually, I want to say it for Mr. Earls, that I think if you consider everything, then in that instance, not just the Watt and just the video, I mean the stills of him shooting into the truck, that you should render a verdict of not guilty. Thanks, guys.
Mr. McLeese, as soon as you have 31 minutes and 25 seconds.
Thank you, Judge. I will not be taking long.
And what kind of reminder did you want?
10 minutes, Judge. Just give me one moment if you don't mind for this thing to get caught up. It takes a minute.
I pause your time.
Good morning. I'd like to start off by saying something that is obvious but needs to be said. And that is what happened to Arlene is horrible. It's tragic. It's every parent's worst nightmare. I don't wish that upon anybody. The Alvarez family did not deserve that. They do not deserve the pain that they're going through. Okay? We are not here to suggest otherwise. We never have been. I don't think you think we are, but that needs to be said. And you're about to be given a superhuman, Herculean task that's very hard to do. And that is to separate this tragedy from your duties as jurors under the law. Okay? You've got to put aside the heartstrings that they're about to get up and pull on heavily. All right? They're very good at it. They're going to get up and pull on that heavily. But I do think that when you look at the instructions that are given to you by this judge, okay, these instructions called a jury charge, 20 plus pages of instructions, your guidebook, okay, it's going to take you to the right result here, the just result. In this case, okay, let's talk about what you're here to decide, what you're here not to decide. You're not here to put a stamp of approval upon anything that happened. That's not it. You're solely here to decide whether or not the state proved, beyond all reasonable doubt, whether Tony was reckless that night from his standpoint. Okay, when we say reckless, we're also, and I'm going to go over this in more detail in a minute, we're not saying the word reckless like we might say if we're having a cup of coffee. Okay, it's a very specific legal definition that you're going to need to apply. Now, I've got a couple of things up here that we first visited about in jury selection. Remember, this is the presumption of innocence, all right? Maroon, Mr. Catani, like to talk about order of things in the jury charge. This is the first one, presumption of innocence. Your default setting is not guilty. And to get beyond that, they've got to prove everything to you beyond a reasonable doubt. Now, along with what Mr. also said, they spent a whole lot of time over a week dissecting, to use Mr. Jordan's words, frame by frame by frame of something that we've never really contested, and that is that the gunshot came from Tony Earls. Okay, I wish it didn't, but it did. That's the situation that we're in. But what you need to look at, you need to guard against legal sleight of hands that are being done. Okay, and it is not insignificant the decisions that are made by prosecutors who are this experienced to not include any investigators, any detectives. There were multiple ones out there. We heard about that. None of them came to you. Okay, they brought one first responding police officer to you. They brought a couple of the crime scene people to you. But think about what they did not bring, all right? That didn't make you wonder why? That's not by accident, okay? We introduced the crime scene video. They didn't. Why? Not by accident. There's a lot that they're wanting to take, to use the analogy Mr. also made earlier. They're in the replay booth trying to circle, receiver that may have been open and not considering it from Tony's standpoint with everything that he had going on. So let's look at the specific allegations, all right? And this is good. I took some bullet points here, but this is what it is. He's accused of recklessly causing the death of Arlene Alvarez by discharging a firearm in the direction of a motor vehicle. And then this is the weird one, while making no effort to determine the identity of the occupants of the motor vehicle. It's up to you to determine whether that constitutes recklessness, okay? We are here to say that under these circumstances, it does not. We are not saying there's open season on shooting cars, all right? That's not our point. This is a very, very, very unique set of circumstances. So manslaughter is our charge, recklessly causing the death of an individual. This is where I think they failed, all right? This is where they failed. They have to prove beyond all reasonable doubt that Tony was aware of but consciously disregarded these risks. And I'm here to tell you, it's not just the risks of a firearm, okay? It's this specific set of circumstances, okay? How could Tony have known that given everything that went on here? This is a tragedy. It's a tragedy. But him being involved in this tragedy does not make him a criminal. This is where we start off, okay? They never showed you this picture. We had to bring it to you. Why? Because they don't like it. Because it humanizes Tony. He's just trying to make a deposit so he can go to dinner. That's all they're trying to do, and a gun gets put in their face. That's an experience I hope no one else in here has to go through. I can't imagine the horror. It's nighttime, and you're seeing your entire life pass before your eyes, and then it triggers, we heard Dr. Lambert talk about this, it starts to trigger chemical reactions in our body, all right? And it gives us, Mr. Jordan, very skillful cross-examiner, was trying to make it sound like you're either in fight mode, or you're in flight mode, or you're in fear. I'm here to tell you, as the doctor did, these all converge, okay? These all converge. This is a chaotic, terror-filled situation. All of these emotions, all of these things are converging, and Tony is reacting. He's reacting. He's not even, we heard about that, the whole frontal lobe starts to shut down. He is reacting to the situation. So we have, at the very beginning, and I'm going to tell you this is a fluid situation. At the very beginning, and they concede this, okay, when he's shooting, under Texas law, he is allowed to shoot at this guy, okay? He's allowed to. There's not any dispute on that, any more than there's any dispute that Tony's the one that shot at the car, okay? These are things that are not in dispute. At that point, okay, they think that as we get to the vehicle, that Tony should have made an effort to determine the identity of the occupants of the vehicle, and that it was not reasonable for him to not do so. But what I'll suggest to you is when we look at the evidence, and look, y'all can get all of it. Look at it as much as you want. Okay, go through it. But you need to go through it. The law is instructing you, you do this from the actor's standpoint, from Tony's standpoint, all right? That chase sign, yellow circle, right, and this is what I was talking about, and this horrible constellation of events. You've got right as the robber is running, all right, he goes behind that sign, and it happened to be right when the truck is slowing down. It's not Armando's fault he was slowing the truck down. He's dealing with the same stuff everyone else is in this situation, trying to figure out what to do. We're not blaming him. But right as the truck slows down, that is the exact time that the runner's there. It's right behind that chase sign. It was, I am going to tell you, a reasonable thought for Tony to believe that that truck that was slowing down, you see the brake lights on right there, okay, that it was picking up the robber. And at that point, it became a threat. A threat where he is allowed to defend himself. Okay, because you can watch the video, watch the way the truck's maneuvering. Tony doesn't know what's going on. He's firing this, he is firing as rapidly as he can because he is in fight or flight mode. All right? his self-defense is presumed reasonable. This is on page 9 of your jury charge. Okay, if he knew that the person against whom force was used, okay, and he believes he's using it against the robber, and I believe, and I'm submitting to you, that's a reasonable belief based on this evidence. He did not provoke the deadly force of the robber. No one's suggesting he did that. He was not otherwise engaged in criminal activity, okay? With that, there's a presumption there on self-defense. And I'm going to get to what Mr. Catani was talking about, the innocent third person here in a minute, but I'm going to preview here for you, okay? All of this everything we're talking about concerns recklessness. If the first definition you need to look at when you get back there is recklessness. Was he aware? Was he actually aware? There's a separate charge for when you ought to be aware. Okay, there's a separate charge. That's not what they brought here. They brought is aware. Okay? And once the self-defense issue is raised, and you'll read it here, this isn't me, this is instructions coming from the court. Once self-defense is raised, they have to prove beyond all reasonable doubt that he did not act in self-defense. Okay, that's and it's been raised. So that is also on their burden. Not only do they have to prove that he acted recklessly, they have to prove that he did not act in self-defense. All right, so to prevail, they essentially have to say that Tony did not believe his conduct was immediately necessary to protect himself against the robber, and that this belief was not reasonable. All right, so this is something that they've done a lot of work, the prosecutors have, to try to minimize this. Okay, and one of their witnesses was even saying, well, I don't know if that's a gun. What do we do? Again, like I question with the witness, he ain't waving goodbye to Tony over there. Now, on this one, this particular shot, is Tony's view blocked? Perhaps, okay? But there's 2 times where we see him, where we see the robber with his hand back like that, all right? Once before that truck, once after the truck. And I'll submit to you that if he did it before the truck, he did it after the truck, he very well may have done it here when we're not able to see him, all right? I've never heard of the state giving so much benefit to an aggravated robber as they have in this case. And the reason that they're doing that is because we know good and well the robber should be in this chair. He's the most responsible. But they got to have someone that they can get a scalp from to give you. Reckless injury to a third person. Again, don't be distracted by this, okay? This is all if you do not believe that Tony was reckless, and we're telling you he was not, then this is irrelevant, all right? So for you to believe that he was reckless, you have to believe that he knew. He understood that after the stress of this event, when he's having a gun pointed at him, and he doesn't know what's going on, okay? And by the way, let me also say this. There's a lot of confusion as to whether or not he's being fired upon. All right, Armando was confused by that. Tony was confused by that. And I'll tell you, in a situation like that, I'm not blaming anybody except the robber. It is natural to be confused when your head is being flooded with such conflicting information. Okay? Again, from his standpoint, what he saw looked like the robber was getting in there. We know that the robber was at the very least pointing guns in the direction. All right, so with all this, we look at this with what we call the totality of the circumstance, and I'll tell you, they did not meet the burden of proof here. They did not prove to you beyond all reasonable doubt that Tony knew that this was going to be the result. No one thinks, and I don't think they're even going to say that Tony woke up that morning wanting to hurt anybody. We all know that. We're here because of horrible circumstances. A lot of people in the wrong place at the wrong time. And a robber who's not here. I'm going to turn over the floor to Ms. Funes.
You have 17 minutes and 40 seconds. 17:36.
This case starts with heartbreak. We've all acknowledged that. No one here thinks that what happened that day is not a tragedy. Tony doesn't think that that's not a tragedy. You have to separate emotion from this case. When you get back there, you have to separate emotion. You have to follow the law. Every time that you feel like emotion is taking over, because it's normal, it's natural. There's a dead 9-year-old. We all acknowledge that. We know that. We've acknowledged that every step of the way. Every time you feel that emotion taken over, we ask that you step back and you follow the law. We ask that you remember the facts of this case. All the people that they've brought to you, I believe it was Mr. Caldwell. He said, I think the jury would benefit from pausing and slowing it down in order to better understand it. Well, guess who didn't get to pause and slow down? Tony. Tony didn't get to slow down and pause what was happening. He had seconds to make a life or death decision. Mr. Alvarez twice, under oath, said they were shooting at each other. He believed they were shooting at each other. That is what he saw. And Dr. Lambert said that is normal. His reaction is just as normal as Tony's reaction. It all happened so fast. Does that mean Mr. Alvarez was lying? No. What he believes he saw may have been accurate. It all happened so fast. It was traumatic for everybody involved. There was a gun pointed at Tony and his wife. They want you to forget about that. They don't want you to think about that because the robber's not here, because nobody has found the robber. Because the person who should be sitting right there is the robber. They reminded you over and over that you're citizens of Harris County. As citizens of Harris County, you should be demanding that the robber be sitting there. I believe it was CSU told you, well, no, we didn't swab anything. The swabs are too expensive. So you have a robber who pointed a gun at a family, who caused all of this, a dead 9-year-old, and CSU comes in and tells you, well, no, we didn't swab. Swabs are too expensive. We heard that there was a Detective Farrell. Where is he? Why didn't they bring him in? The undisputed facts. They brought you people, like Mr. also said, who only got involved in this case a couple of months ago. This case has been going on for 3.5 years. They brought you people that would show you things slow down from their perspective, not from Tony's perspective, not people who were involved in the investigation. And Mr. Catania was very adamant about that last shot. When Tony gets out of the car and he says, well, he made that last shot as he's pulling out of the car, out of the driveway. Well, did he forget that he also showed us that video where the Alvarez family and Mr. Alvarez testified he's waiting at the street, down the street, for Tony? You see his brake lights in the reflection. He waits 17 seconds, he's waiting down the street. And as Tony's wife is pulling out, they realize they're waiting on them. He then reverses.
Outside the record.
The jury heard
That's what the
evidence in
video
this case.
shows.
Statement of motion, I've given you evidence comes from the stand. You guys get to believe who you want to believe. I mean, you may continue.
He reverses by his own testimony. He says he reversed. He then makes a U-turn and decides he's going to chase Tony. How is Tony not supposed to think that the truck is involved in the robbery? He thinks the robber's coming back for me. That's what that last shot is. The robber's coming back for me. I am in fear for my life. It's not this, I'm just going to shoot down the street. The robber's down the street waiting on me. That's what Tony believed. He said, I waited, I reversed, I made a U-turn and started chasing him. Call it whatever you want. He tried to say, no, I wasn't going to chase him. It wasn't a chase. It wasn't a chase. He chased him, and you see it in the video. Now, they each may have been erroneous in what they believed, but Tony thought the truck was involved in the robbery. How was he not supposed to think that the truck is involved when he gets out and sees him waiting on him? What else is he supposed to believe? Now, these 5 shots that Mr. Catani says, it's just somebody packing cigarettes. Packing cigarettes. Well, you know who could have told us whether it was packing cigarettes or 5 shots? The detective. Why didn't they bring him? He would have answered that question. So yeah, we're left to speculate whether it was shots or not. In his opening, Mr. Jordan said, Tony had a right to shoot the robber. He told you that. We don't change the evidence to fit the theory of the case. The evidence is what the evidence is. Twice, Mr. Alvarez said they were shooting at each other. Like Mr. Rosso said, the things that they didn't bring you, the detective, the CSU video that we had to introduce, and what Tony told them. When you get back there, you can ask for a readback of what Mr. Alvarez said from the stand. Now we watch the body camera. As soon as the police arrive on the scene, Mr. Alvarez says he thought we were involved with the robber. That's why Tony shoots. He's not just out there shooting at random vehicles. He's not this angry person that Mr. Jordan would like him to be. He thought we were involved with the robber. See the brake lights. You see them waiting. Why didn't they bring you the camera from the front of the building that would have shown Mr. Alvarez's truck? All we have is a reflection. All the things they didn't bring you. But they want to make up for it with emotion. Yes, there's a dead 9-year-old. We know that. But you still have to bring the evidence. You still have to prove your case. You don't get to make up for it with emotion. We don't convict people based on emotion. One of you during jury selection said that's why he was here, because he believed in the justice system. We don't convict people based on emotion. We convict on the law. We follow the law. Based on the law, you must find Tony Earls not guilty.
26 minutes and 25 seconds.
I was going to say that first. You stop my time first.
Never started.
Okay.
He was waiting down the block there. Y'all remember the testimony. What Armando said is he stopped his vehicle and got out and walked the back of the vehicle and checked on Arlene. That's what he was doing. Isn't it funny how all three lawyers told you don't base this on emotion? And then they all talked about emotion. They all want you to be emotional about this defendant. They all say, you gotta feel what he was feeling. You gotta understand what he was feeling. Ed is yelling, Anna is soft, and Anthony is accusing me of impropriety. But don't base your verdict on the emotion. Life is emotional. But if you notice, the evidence we brought you was not emotional. It was analytical, and it was logical. We can't escape the reality of what this case is. Emotional for everybody. I want to address a couple of things that they said first. The law allows me to respond when they talked about not bringing the homicide detectives. And Mr. Oso suggested that they must not agree with the case. This is the way, and I'm allowed to say this because it's a response. This is the way this works. If any police officer or any homicide detective involved in this case
disagreed with it, I'd be obligated ethically to tell them. And they would have brought him. So that is just not true. The reason why you didn't hear from homicide detectives is because this case wasn't a whodunit. Besides interviewing the defendant's wife, there's nobody else to bring you. They seized surveillance video. And so what we did is we brought you the facts in the case so you could know what happened. There's no better evidence than that. It's funny, they always complain about too many cops. Now they're complaining there's not enough. Y'all can know the evidence. I want to talk about this thing. It's like they were saying, oh, well, you know, we're not disputing they shot in the car. Well, these are the shots. First, they claimed he shot first. Then they claimed the lack of muzzle flash was because the robber got some kind of special bullets. Y'all remember that, right? Well, now
This
we
objection
know.
mischaracterizes the evidence.
Same instruction, you heard the evidence, you guys can determine what the evidence is based on the testimony and the witnesses on the stand. You may continue, sir.
And now they still are going on a video from across the street. They did it again in argument. You see, they're crossing paths, so of course it's reasonable for them to think that he got in the car. Remember, what the law says is you're in the defendant's shoes, not in his mind. The defendant would never have seen them cross paths. We know that. He goes into the dark of night and he starts shooting into the next vehicle. But they keep showing that, so you start thinking that it was reasonable. And it was not. Maroon was right. This is actually very simple. Y'all can go back there, and the sole issue before you, is it reckless to shoot into a vehicle when you can't see in? Period. Hard stop. That's the decision. And we all know that's the case. But don't base it on emotion. You notice what they do? They keep calling him Tony. Tony this, Tony that, Tony that. It's Mr. Earls. A 9-year-old is called by her first name. And seems like she's kind of been absent from this trial. It's all about him. Let's talk about him. His wife was clearly fearful. At that moment, they were being robbed. They didn't know what was going to happen. We all know that. But he got out of that vehicle angry. He got out of that vehicle, make no mistake of it, and the law allowed him to do it, is he could have shot that robber and killed him for the property. But make no mistake of it. Y'all can start debating this back in the jury room. That man decided he was willing to kill somebody over a wallet, 20 credit cards, and $20. That's what was in his mind. He was already ready to kill. But then, once he does the shots, he doesn't get back in the vehicle and flee. He then goes to that open space, angry. And he starts shooting at the next vehicle. And that's the sole issue before you. Is shooting into a vehicle that you can't see in a reckless act? And we all know it is. We don't have to prove he knew Arlene was in there. If he knew Arlene was in there, he'd be charged with capital murder and be facing the death penalty. All we have to prove is it's a reckless act. It's not justified to shoot into the vehicle when you can't see the occupants. You know, there's been some talk about this robbery suspect. There is a suggestion somehow that this robbery suspect is responsible for Arlene's death. And make no mistake of it, we would love to have captured him. But it isn't his actions. It's his actions that caused the death. And it helps you to know that that was rather probably not either a real gun, 2, a gun without bullets, or 3, if it was a gun with bullets, he had more restraint than anybody, because as he's being shot at, he's not shooting.
Judge, I object. That's a mischaracterization of the evidence.
Same instruction. Tired of repeating it. You heard the evidence. Testimony.
But that didn't matter to Tony Earls. To Tony Earls, it was worth killing. And he did not care. You know, we talked a lot during jury selection about guns in our community. And some of y'all on this jury are into guns, and that's a good thing. Some of y'all are not, but you respect those who do. And folks who carry guns, we all know there comes a responsibility when you choose to arm yourself. When you choose to purchase a weapon and have it on your person, you are responsible for your actions. And yes, the very laws that give you the right to kill to get your property back, the very laws that allow you to defend yourself, is also the very law that protects the Alvarez's family. Because you know there's a right in our community that we haven't talked about. There is a right for a family to drive in the Gulf Gate area to a pizza parlor. There is a right for a family to be able to drive down the block on Valentine's night. Have you thought about that? The day of love. And they're driving to dinner. They have a right to not have that man fire into their car because he's pissed off. Make no mistake of it, that man was not fearful anymore. That man decided he was angry and he was going to do something about it. And not only that, he was willing to kill everybody, even if he thought the assailant, the robbery suspect, had gotten into the car. Have you thought about? He was willing to kill not only the robbery suspect, but anybody he was in the car with. Have you thought about that? Because he didn't care. And you know that because after all that, when he's looking out and he sees Armando, he shoots in that direction, again jeopardizing everybody behind Armando and his family into an intersection. And they want you to believe that that was reasonable. They sold you that again. See, guys, if y'all just see that he's passing the car enough, even though it's not my client's perspective, maybe you'll believe he's reasonable. It's in his shoes and in y'all's mind. That's the difference. You don't get into his mind. His mind is angry and unreasonable. It is your
Objection,
mind.
that's a misstatement of the law.
You guys have the jury charge. That's the law in the case. Refer to it.
They showed you this again. Again, trying to affect you with not the facts according to this defendant. I'm going to show you 108 again because it is so important. And there was a suggestion that, yes, he did have a couple of seconds, but you know what? He didn't even think. He just started firing. There is nothing more powerful I can say or words I can string together that are more powerful than what you just saw. What you saw was not an accident. True, it's a tragedy. But a little girl is dead because of the actions of this defendant. And Maroon is absolutely right. When you read that charge and you get to page 6, it tells you that in the course of all this, if you recklessly cause the death of an innocent third party, you go to the verdict room. How else can you interpret this evidence? And it's a reasonable person standard. Yes, you put yourself in his shoes, but you get to say what is reasonable. Most of y'all would never have even gotten out of the car. The rest of you, had you gotten out of the car, you would have
Objection,
gotten
improper argument.
back in the car. It's a
Again,
reasonable
you heard
person
my-
standard.
One second, you heard
Yeah.
my instructions with respect to what they say not being evidence. It comes from the exhibits and the witnesses. You may continue.
Judge, for that particular one, may we have a rule?
It's going to be ruled. You have 7 minutes and 53 seconds.
It's a reasonable person standard, so you have to ask yourself, would I have even gotten out of the car? If yes, that's okay, you're justified. But after that, would you have gotten back in the car?
Objection, Your Honor, invading the province of the jury.
Look at the charge. Y'all decide. Sir, you understand the rules. Please continue.
And
Judge, may I have a ruling?
That is sustained.
lastly, you certainly would not have shot into a motor vehicle when you couldn't see into it. And if as a result you kill somebody, an innocent third party, you know you're responsible. We have talked this entire trial about Tony Earls. It seems like it's lost, that a child lost her life. Have you thought about what the interior of that truck was like as this was going on? I'm going to play you the audio, but we're not going to see anything. And as you listen to it, I want you to think about it. That
Shut that door.
when he is firing those 3 shots, he is firing at someone's back. I want you to think about when you hear shots 4 and 5, I want to remind you of Armando's testimony that when he turned the gun to us after the robber, I thought he was going to shoot Wendy and I. So then he speeds up when you hear the sound of his tires. Then you're going to hear 6, 7, 8, and 9. And when you hear the 7th one, you know that's the one that hits Arlene. Then there's going to be some silence. And you're going to know that's when he gets out of that vehicle to check on his daughter. But in that silence, I want you to remember what Armando told us. Everybody was screaming. Armando Jr. was screaming, "My sister's been hit. He's got blood all over him." When you hear that silence and whatever they're trying to say is 5 gunshots down the block, I want you to think about that moment. considering all of that, this should be the easiest decision. Because it tells you, no matter what was happening out there, when you recklessly cause the death of an innocent third party, you're guilty of manslaughter. And can there be anybody more innocent than a 9-year-old child? She is sitting in that picture on Valentine's morning in the seat in which 14 hours later she would be dead. You heard the medical examiner tell us that she was shot above the right eye.
2 minutes.
And that the bullet fragments were in the back of her head. What we know from that is when Armando tells us she had her headphones on and he yells to his family, "Get down," she doesn't hear it. But there's a difference between someone yelling in a car and gunshots ringing and you can hear it. So she looks as they're passing and she's looking at the man who would kill her. She is looking at the man and the barrel that would cause
Objection,
her
there's no
death.
evidence of that at all.
How else do you interpret that the shot happened above her right eye as she's looking outside?
Excuse me, Your Honor.
Stop.
I asked
You have
the
an
jury
objection.
be instructed to disregard those last comments.
Disregard that last statement. You may continue. You have 2 minutes left.
You remember. This is why you were here. To put an end to this. And to finally hold this defendant accountable for his actions. And Maroon and I now give it to you. Go back in that room and bring justice.
I've read you the charge. You've heard arguments. Please go with the bailiff. At this time, you can start your deliberations. One shall go in the room. Also, lunch is here. They'll explain the rules with respect to how you can deliberate with lunch, without lunch.
All rise for the jury.